So hello and welcome to this Brodies webinar on the forthcoming UK general election and how the election process works. We've had an incredible response to this webinar. We quite understand why our international clients have signed up to work out how a UK general election works. We're slightly worried that some of our domestic clients don't know that already, but if you have your polling card, we aim to help you with the process this afternoon. We're focusing very much on how the election works. There will be no punditry, there will be no betting on outcomes, and there will be as little by way of politics as possible. To us, I'm Christine O'Neill, and my partner Charles Livingston and I are both partners in our risk, government and compliance team here at Brodies. We both have interest in constitutional law and elections and the outcome of elections. So this is very much our territory, and we're going to kind of do a double-hander in trying to explain some of the key elements of a UK general election. And the first of those, of course, is how you go about calling a general election. And the first thing to say about that is it is not a constitutional principle in the UK that you must call a general election during a rainstorm. That is a new development in constitutional politics in the UK. It's possible to do it in the sun or in any other weather conditions, or indeed from inside a building. So that's the first mechanic around calling a general election. Beyond that, if we move on, there aren't actually very many rules in the UK Constitution, but it's not a totally lawless process. So as you will know, an election follows the dissolution of Parliament, and the dissolution of Parliament is something that happens in the British Constitution by way of the exercise of the royal prerogative. So it's effectively the King who formally dissolves Parliament. Now, that power to dissolve was and continues to be, by convention, exercised on the advice of the Prime Minister. So it gives to the Prime Minister in the United Kingdom almost, and I say almost, untrammelled power to decide on the date of the general election. The Prime Minister will fix a date in his or her mind, will take that to the monarch, and the monarch, in almost every case, will agree to dissolve Parliament at the request of the Prime Minister. Now, that is subject to very little law, but it is subject to a long stop on the length of parliamentary terms of the UK Parliament. So a UK parliamentary session or term has a 5-year limit. That was something that had been in place from 1911, subject to some wartime interventions and extensions of Parliament. And there was a brief interruption, which I'll come to in a moment, but the 5-year term has been restored by the Dissolution and Calling of Parliament Act 2022. So if we move on, that is an image of the Dissolution and Calling of Parliament Act 2022, and moving on, it replaced the Fixed Term Parliaments Act of 2011. So again, if you're like Charles and I, old enough to remember this, the Conservative Lib Dem coalition agreed as part of their coalition deal to put in place a system of fixed term parliaments, which would limit that power of the Prime Minister to decide when an election should be called. And this was principally to protect the smaller party in the coalition, the Liberal Democrats, against the Conservatives deciding on a whim and without consultation or without much constraint to go to the country for a fresh general election and get out of the coalition at a time of their choosing. Now, the Fixed Term Parliaments Act was not popular with all parties, and it was not popular with all sections of all parties, and it was not popular with those who might be described as constitutional traditionalists. And so it was repealed by the 2022 Act. And what the 2022 Act provides for is effectively for the revival of the prerogative power that we talked about earlier. So what is said in Section 2 of the 2022 Act is that the powers relating to the dissolution of Parliament and the calling of a new Parliament that were exercisable by the prerogative immediately before the 2011 Act are exercisable again as if the Fixed Term Parliaments Act had never been enacted. So moving on, this was an interesting little diversion for the British Constitution. The Act could, of course, revive the prerogative power that had been interfered with by the 2011 Act, but it couldn't revive and didn't attempt to revive a convention that power was exercisable on the advice of the Prime Minister. But as we have seen from the calling of the most recent general election, it appears to have been restored. The King was content to dissolve Parliament at the request of the Prime Minister on a date of his choosing. I did say earlier that this was an almost untrammelled power. There are, at least in theory, some circumstances in which the monarch might refuse to dissolve Parliament. Those circumstances are described as the Lascelles Principles, and believe it or not, such an important part of the UK Constitution was set out by Tommy Lascelles, the King's Private Secretary, in a letter to the Times newspaper in 1950, suggesting the circumstances in which the monarch might refuse to dissolve Parliament. One such circumstance would be if the existing Parliament was still vital, viable and capable of continuing, or another Prime Minister could be found who could carry on the job of government without the need for a dissolution. Those are theoretical questions for the most part, but they do place, it seems, some constraint on the prerogative power. So enough about the dissolution and the calling of Parliament Act of 2022. That's how we go about calling an election. Charles is going to talk about what happens to Parliament when the election is called.
Thanks, Christine. So yeah, I will talk about what happens to Parliament and in particular what happens to the legislation that Parliament was working on. You'll see the dates there. So these are the relevant dates this time around. So Parliament is first prorogued to end the current parliamentary session. And you'll get maybe 4 or 5 parliamentary sessions in the life of most parliaments that run a full 4 to 5 year term. So prorogation is something that happens regularly within a parliament. But following on from prorogation, what happens is that Parliament is dissolved. Christine has obviously referred to the dissolution of Parliament. So this time around, Parliament was prorogued on the 24th of May, which ended the existing session, but it was then dissolved as of the 30th of May. When Parliament is prorogued, some business falls, but some business continues. On dissolution, all business in Parliament comes to an end, and that's whether it's in the House of Commons or the House of Lords. And what that means is that any bills that haven't become an act by the point of dissolution will fall and would have to be reintroduced and start again in the new Parliament if a new government or the new parliamentary intake is so minded. So in order to deal with bills that would otherwise fall, see on the next slide, there's a period called the wash-up. And you'll get a wash-up period generally prior to any prorogation. Legislation can, in some circumstances, survive a prorogation. But generally, you'll have a wash-up period at prorogation, and you certainly need one at dissolution. And that effectively means that where bills are relatively uncontroversial, and in particular where most of the work has already been done on them, then the government and the opposition parties can agree procedure that will fast-track them to get them through and get them royal assent, as in signed by the King, to actually become an act. So a few of the bills that were expedited and therefore saved in relation to the existing parliamentary term. Was the bill, be very familiar to our domestic audience at least, quashing the convictions of various sub-postmasters who had been found guilty of offences relating to the Post Office's Horizon IT system. The Victim and Prisoners Bill, which included some provisions in relation to the outcome of the infected blood inquiry, which closed just a couple of months ago, and also a bill that I've been following very closely in terms of our competition practice. The Digital Markets Competition and Consumers Bill sets up a new digital market regulation regime, also makes some relatively important changes to the enforcement of competition law and consumer protection law. But there were other bills that were before Parliament which, if Parliament had run its full term, could have got through, but which fell at dissolution. One of those is update to the data protection regime in the Data Protection and Digital Information Bill. Another is the Tobacco and Vapes Bill, which is ironic because that's one of the things on which that the current Prime Minister has identified as a legacy item, but it will only become so if it's taken up in the next Parliament because it fell. That's what's called the generational tobacco ban, and also quite a lot of regulation around single-use vapes and vape flavours and that sort of thing. And also the Renters Reform Bill, which was quite an important piece of legislation in relation to the private residential rental sector in England and Wales. There was a lot of secondary legislation that was in process. Now that doesn't necessarily fall, it depends on the procedure. So some secondary legislation is made using what's called the affirmative procedure, which means it can't be made unless Parliament has consented to it. Where there's no Parliament, you can't get that consent, so that won't that sort of legislation won't go through, and we'll have to wait. There's also there's a negative procedure where secondary legislation can be made unless Parliament votes to block it or to rescind it. Now, we're obviously where you don't have a Parliament, that can't happen, but the time limits for doing that will survive into the new Parliament. So moving on to our next section, I'm going to talk about what happens to MPs and what happens to the government when Parliament is dissolved. The answer is that dissolution brings the old Parliament to an end, and in doing so, it vacates all seats in the House of Commons. So as things stand, there is not a single MP anywhere in the United Kingdom. There are no MPs until after the election. Members of the House of Lords remain in position because obviously that is an appointed rather than an elected body, but as I said, no business is carried on in the House of Lords. The government, which is on our next slide, is a bit of a different story. So the government remains in place. We don't cease to have a Prime Minister because Parliament is dissolved. So the Prime Minister, Secretaries of State, other ministers, they remain in post despite no longer being MPs, and they can no longer put MP after their name. So the government remains in place, but its activity is restricted during the pre-election period. And that's the period from dissolution up to the election. It used to be called, and is frequently still called, purdah, but that term is disapproved of now. So pre-election period is the phrase to use. And that restriction basically takes the form of advice to civil servants primarily, requiring them to take care, at least take care with and possibly avoid anything that's politically sensitive during the campaign period, including the use of public resources for matters that might be relevant to the election, so that might swing some people's votes. The making of announcements, particularly on sensitive issues, any activity that could call into question civil service impartiality, and indeed business on which a new government might want to form its own view before before the horse escapes the stable. And as part of this principle, new business is generally deferred. This guidance is primarily for civil servants working for the UK government, but at the very least, the principle is also respected by the devolved governments and by local authorities. So, for example, the Scottish Government has delayed the issuing of its programme for government as a result of the pre-election period. hand back to Christine to talk about the campaign.
Yeah, so we're in the campaign, I imagine you have noticed, and the two things in particular that are quite heavily regulated during the campaign, as you would expect, are first money and second campaign publicity and advertising. So if we start with money and we move on to the next slide, if you want to see what individual politicians or parties have received by way of donations and from whom, there is a very interesting Electoral Commission searchable database available to you. And I, this morning, searched against the really unimaginative name John Smith, and I am showing you the first several items of many pages of results for John Smith, showing you donations by John Smith, but donations to other people called Smith by people who aren't called Smith at all. So you can go and play with the Electoral Commission searchable database if that is your thing. And I am assuming that is your thing because you would not be on this webinar if you were not, like Charles and me, election geeks. So there's a toy for the rest of the day. If we move on to the regulation of money for campaigns, I've given you the list of the main pieces of legislation that govern campaign money. We'll deal firstly with political party spending, and political party spending is limited during what's called the regulated period. And the regulated period for this election is from the 6th of July 2023 until the 5th of July 2024. So you may not know exactly what the regulated period is until the general election is in fact called, because it tends to be 365 days ahead, or perhaps this year 366 days ahead of the election. Charles is querying my maths, but can no doubt come back. In any event, the actual limit on what you can spend if you're a political party depends on which part of the UK you're standing in and how many candidates you have. So if we go to the next slide, there's a table that is shown on the Electoral Commission's website, which shows what the limits are. And those limits are either the numerical limit in the table for each of the nations of Great Britain, or just over £54,000 per seat in which your party is standing. So if you are standing in a substantial number of seats, then the overall spending limit will be higher than these minimum levels. If we move on, quite aside from the absolute limit on spending, there are detailed rules on what counts and doesn't count as campaign spending. And it can get quite complicated because, as an anti-avoidance provision, spending during the regulated period includes using things that you bought before the regulated period but hadn't used before that regulated period. And it excludes things that you might buy just now during the regulated period, but you don't use them up. And the Electoral Commission is very clear that if you are not using things that you've bought during the regulated period and you want to get credit for having not used them, you have to make sure that you've got evidence that you bought them, that you've kept them, or that you've destroyed them. Spending isn't just about cash paid out by a party, but also includes benefits in kind, including, for example, space at a venue for an event or food and drink for volunteers. So that still counts as money that you have dedicated to your campaign. And if you're a political party, you have to comply with the detailed rules on reporting to and monitoring by the Electoral Commission. The things that count as spending are the things that you would expect: party political broadcasts, party advertising, leaflets and the like, but doesn't include some things that are, in my view, quite surprising. So if you hire a venue for an event, that is spending, but if you hire bouncers to protect the event, those are not spending for the purposes of the campaign, and nor, for example, is, and it's an example given by the Electoral Commission itself, paying for antivirus software to protect your digital systems. So potentially places to trip up if you're a political party, which is why, of course, the major political parties have people whose jobs it is to make sure that they keep track of all of this. So if we move on to the next slide, I've just talked about what you can spend money on and what the limits are on the amount of spending. There are also rules on where the money can come from. And in particular, there are rules around the source of donations. Donations of more than and loans of more than £500 must be from what are called permissible sources. And there is a list of what amounts to a permissible source, but broadly speaking, this is to restrict campaign finance to UK-based donations and loans, and to exclude foreign campaign funds. So UK voters, UK-based companies, UK trade unions and businesses will be permissible sources. And of course, the Electoral Commission keeps track of all of that by requiring you to record and report to the Electoral Commission the donations and loans that you receive as a political party. In addition to controlling campaign finance for political parties, there are also rules around candidates. So restrictions for candidates are different whether we are in what's called the long campaign or the short campaign. Now, we're actually in the short campaign just now, however long it may feel, and a long campaign only happens if Parliament is close to getting to the very end of the 5-year term. So we were far away enough from the 5-year long stop date when the Prime Minister called this general election that there is no long campaign period, but the short campaign period began the day after Parliament was dissolved. And there's a very intriguing limit on candidate expenditure in a constituency. If you're standing as a candidate for election to Parliament in this election, you may spend £11,390 plus an amount of money which reflects the number of registered voters in your constituency and is different if you are in an urban seat. In Scotland, they're called borough constituencies, or you're in a rural seat known as county constituencies. You get 8 pence per voter in an urban seat and 12 pence per voter in a rural seat. And rather than being monitored and regulated by the Electoral Commission, individual candidate spending is regulated and monitored by returning officers for elections and by the police. So if we move on from money, the other thing that is regulated is advertising and publicity. There's very detailed rules around this, and again, those who are in the business of electioneering, but also those who are newspapers, broadcasters, publishers, are very familiar with these rules. But in summary, printed campaign material must carry what's called an imprint showing who is responsible for its production. So you should be able to see when you receive election campaign material that it is in fact official election material, and it should tell you who has produced that material. It should tell you who is the promoter of the material, and it should tell you also who has printed that material. We're talking here about what's called candidate election material, so leaflets and adverts that can be reasonably regarded as intended to promote or procure the election of a candidate. And that, importantly, includes material that criticises other candidates. And the way this is enforced is by putting a burden on the printer and promoter, because if they publish election material without an imprint, they may be guilty of a criminal offence. So moving on, There are separate rules for digital material, and what is digital material is also relatively complicated, but it's material in electronic form that consists of or includes text, moving images, still images, speech, or music. Telephone messages and texts are excluded, but material that's published on platforms like WhatsApp would be included. And importantly, the rules here apply to material that's published outside of the UK if it's made available in the UK. So if you can search for it and find it on the internet in the UK, it will be governed by these rules. Now, the rules distinguish between what are called paid adverts and organic material. Now, organic material in normal language has a very different meaning, but that's a distinction in relation to digital material. And a paid advert must have an imprint if it is political material. And if we move on to the next slide, organic material must have an imprint if it is election material, referendum material, or recall petition material, and is published by or on behalf of a candidate or a registered political party. We're not going to go into all of the different categories of material that require to have an imprint. Publishing will include republishing, so retweeting something that you have seen on X, but there are protections in relation to retweeting or republishing. The main one being if you simply reproduce something that has been published with its imprint, you don't interfere with that, and you republish the imprint too, then you should be protected. And publishing without an imprint may be an offence on the part of the promoter or any other person on whose behalf the material is published. So that's the campaign. We will get to the end of this campaign in the next fortnight, and Charles is going to talk about what happens at the end of the campaign.
Thanks, Christine. So speak briefly about how MPs are chosen, and then in a little bit more detail about whether election results can be challenged. So how are MPs chosen? Relatively short slide. There are 650 constituencies across the UK. Each constituency chooses an MP via first past the post, meaning that the person with the highest number of votes in the constituency wins the seat. They don't need to win a majority, just the biggest number. The votes are counted and announced, and I should say actually, so votes can be cast in a few different ways. Most people vote in person on the day. You can vote by post or by proxy. If, like me, you're going to be on holiday for the election and you haven't requested your postal vote, today is the last day to do that. We did not deliberately time it that way, but if you haven't got around to it yet, you need to get it done. So the votes are counted and announced by the returning officer, which is usually an officer of the local authority for the constituency. So you'll have different arrangements in different places. In some places, the returning officer will only have one constituency. So East Renfrewshire Council, for example, overlaps entirely with the East Renfrewshire parliamentary constituency, whereas in Glasgow, you may have the same officer acting as a returning officer for all 8 Glasgow constituencies. That may be the wrong number, but it's roughly right. And then MPs will be sworn in shortly after the election. Not all 650 of them, though. It's been a long time since there have been 650 because MPs from Northern Ireland who stand for Sinn Féin don't take up their seats because they won't take the oath. So you don't actually get 650 MPs sworn in. Can election results be challenged? This is governed by Part 3 of the Representation of the People Act 1983. There are 66 sections in there, so it's some fairly chunky stuff. Some of those sections have been repealed. Some are about local government elections only, but it's still pretty detailed. But the rules are that an election, or in a UK Parliament context, a return, meaning the result, can only be questioned by way of a parliamentary election petition that complains of an undue election or undue return. And a petition can be presented by any voter from the constituency in question, or a person claiming that they had a right to be elected, or in this case returned as the MP, or any candidate, whether or not they say they would have been successful. And the respondent to the petition is the person whose return is the subject of the complaint, so the person who's been elected, although it can also be the returning officer or officers if their conduct is part of the complaint. There is a 21-day time limit to bring a challenge, which starts with the return of the member being made to the Clerk of the Crown in Chancery. There's lots and lots of these sort of titles that come up around elections. There are exceptions to that for bribery, if the complaint is that somebody was elected and then after they were elected or sworn in, they paid off the voter at that point, 28 days from the date of payment. Similarly with illegal practices, if overspending is uncovered because of a financial return, then the time starts to run from that financial return. The challenge is then heard by the election court, which is on our next slide. An election court is 2 judges. So in England and Wales, there are 4 election judges on a rota from the King's Bench division nominated annually by the president of the division. In Scotland, the Lord President of the Court of Session nominates 2 judges to be the election judges for that year. And in Northern Ireland, it's 2 judges of the High Court or Court of Appeal selected under Northern Irish judiciary legislation, which is too niche even for this webinar. There are specific sets of court rules for election petitions, and they're normally tried in the constituency in open court without a jury. There's some flexibility around that in England and Wales, but I think not in Scotland. I think it has to be in the constituency. On our next slide, what happens, what can happen. So the court determines whether the member was duly returned or whether the election was void. Those are not necessarily the same thing, and certifies its decision to the Speaker of the House of Commons. Obviously, it's 2 judges, so you might have a disagreement. If so, then they will certify the fact of that difference, but the member is deemed duly returned. If they agree on the outcome but differ on the reasoning, then the election is deemed void. So if they agree the member wasn't duly returned, then that's sufficient, even if they disagree on the reasons. And an election will be void if the candidate was disqualified from membership of the Commons, so was never eligible. A candidate is found guilty either personally or through an agent of any corrupt or illegal practice, although they can try and persuade the election court that if it was through an agent, that agent was essentially acting without their authority and contrary to orders and that sort of thing. And likewise, an election can be void if corrupt or illegal practices or illegal payments, employments, or hirings were so extensive they may reasonably be supposed to have affected the result. Similarly, if a candidate was guilty of bribery or treating, which is not quite bribery, but it's like bribery, or undue influence in respect of a voter, then that voter's vote is struck off. So even if somehow the candidate's election isn't void, you can start taking numbers off their tally, and it may be that they end up in second rather than first place. Similarly, if if a voter is found guilty of those things, their vote will be struck off, as will the vote of any ineligible voter. Now, these sorts of things will only form the basis of an election petition if there are only a few votes in it. By and large, you're more likely to get it through allegations of corrupt or illegal practice on the part of the candidate, and we'll come back to an example of that. So on the next slide, if the petition alleges corrupt or illegal practices by the candidate or by any other person, the court must investigate that. So it has a quasi-investigatory role that British courts tend not to have, or almost never have, in fact. But the court has to investigate that and report to the Speaker on whether there were any corrupt or illegal practices, particularly committed by or with the consent of the candidate, or indeed by any other person, and including whether those practices may have extensively prevailed at the election. And the court can also make a special report to the Speaker if something comes out of their hearing that they think the House of Commons ought to consider. The House of Commons then considers any certificate or report sent to them by the election court and gives the necessary direction to either confirm or alter the challenged return, can issue a writ for a new election, so if there was pervasive corruption, or otherwise do things to give effect to the court's determination, including making any order it thinks proper in relation to a special report where there have been corrupt or illegal practices. Any person who's reported to Parliament as having been personally guilty of a corrupt or illegal practice becomes ineligible for election and must vacate their seat. So that's not necessarily the candidate. So you might have a candidate guilty of a corrupt or illegal practice, their election is void, but you might also have somebody who is an MP who was involved in that wrongdoing and is therefore themselves guilty of a corrupt or illegal practice, even though their own election wasn't challenged. So the example that I mentioned, the most high profile, I think it's fair to say, election petition in some years comes from the 2015 election, and it involved a challenge to the election of the former Secretary of State for Scotland, Alistair Carmichael, who was prior to the election and at the election was returned as MP for Orkney and Shetland. And the constituents' petition alleged an illegal practice per section 106 of the Act, which is the illegal practice of making a false statement as to a candidate's personal character or conduct without believing on reasonable grounds that it was true, for the purpose of affecting the return of the candidate at the election. So very briefly, the background on that was that there was a Scotland Office memo that purported to record a discussion between the then First Minister of Scotland, Nicola Sturgeon, and the French ambassador, which, to cut a long story short, suggested that Nicola Sturgeon would have preferred, or the SNP would have preferred the Conservatives to win the 2015 election because that would give them something to campaign against, give them more to campaign against in Scotland. So that was leaked to the Daily Telegraph in April 2015. The content was hotly disputed by both the SNP and indeed the French diplomatic service disputed it as well. So the story quickly turned to how and by whom it was leaked. So Mr. Carmichael gave some interviews in the media denying the leak, but then later, when it was investigated by the Cabinet Office, he admitted that he had, in fact, authorised it. So what the court decided, having established these facts, is on the next slide, and it decided that Section 106 encompasses false statements made by the candidate about his own personal character or conduct, and those statements can be made to affect his own return as a candidate. So it covers falsely talking yourself up as well as falsely talking your opponent down. The court in that case was satisfied that the false denials about the leak were made for the purpose of affecting Mr. Carmichael's return at the election, because anything that harmed the SNP's chances would help his chances in an SNP Liberal Democrat marginal. He was the Liberal Democrat. But the court was not satisfied that the statements were about Mr. Carmichael's personal character or conduct. They said that it was about his awareness or otherwise of what the court called a political machination, rather than anything personal to him. Yeah, they did refer to, I think the phrase was a basic and straightforward lie or something like that, rather than something about his conduct. He wasn't saying he was not the sort of person who would ever do a leak. He was just saying that he had in fact not leaked the information, and that was the false statement. So the court decided that he had not committed an illegal practice and had been duly elected, and his election was therefore not void. Christine?
And so if we get past all of those potential challenges, we have an election result. The very last question is how in the UK we form a new government. And the answer to that is that there are even fewer rules and almost no law. So if we move on to the next slide, as Charles has already explained, until the election result is known, the Prime Minister and the government as a whole remain in office. We don't have a gap in service. And if the incumbent was to win, there would be no break in service and they would continue as Prime Minister, subject always, of course, to their party agreeing that that should be so. If the incumbent loses, then they are expected to resign. And by convention, the winner must be invited by the monarch to be Prime Minister and to form a government. Now, that applies where there is a clear winner and where there is a clear loser, and complications can arise if no party secures an overall majority. And that may be something that we can talk about in the question session, because we are at the end of our formal presentation. We're very happy to take questions for the next few minutes if you have any. We have a question asked at an earlier point about digital media and whether we've got views on buying website domain names or social media handles and whether those amount to digital material. The questioner has remained anonymous, which suggests to me they may know the answer better than we do, but my reflection would be that I wouldn't have normally thought that the domain name or the social media handle themselves would amount to relevant digital material for the purposes of the publication rules. But in a quotes extreme case, if the domain name, was very clearly vote X or vote Y, that might count. But my general view would be that the domain names themselves, the social media handles, wouldn't be covered, but anything posted on those might well be. Charles, do you want to take any of the other questions?
Yeah, so there's a question about when Parliament will start to legislate again, which gives me the opportunity to read the proclamation, the King's proclamation that dissolved the present Parliament, because it also calls the next. Having dealt with the dissolution part, it reads, "We being desirous and resolved, as soon as may be, to meet our people and to have their advice in Parliament, do hereby make known to all our loving subjects our royal will and pleasure to call a new Parliament." And then there's further flowery language to that effect that ultimately results in Parliament resuming on the 9th of July. I love the reference to loving subjects. If anybody's seen Hamilton, that will immediately put that song from King George in your head. So Parliament will resume on the 9th of July. All the MPs will be sworn in. Unless there's something that needs to be expedited, it will be a while before we actually get any legislation out of the Parliament, because obviously it has to go through that process. And if there's a new government, then it'll probably take longer because they'll need to start their own legislation from scratch, which is why, if you think about the 1997 election, that was a change of government with a very large majority. A lot of the key legislation from that we still work with is from 1998, the year after the elections, the Human Rights Act, the Scotland Act, the Competition Act. So probably be a while before we get major legislation coming out of Parliament again.
And I'll just round off with a question on what happens if there is a hung Parliament, which is to say, if there is no clear winner among the major UK parties as to who should form a government. And again, being very terribly British, the main issue in the event of a hung Parliament is not to embarrass the King. So the Cabinet Manual, which gives guidance on this, makes it plain that whatever is done, the monarch should not be placed in the political kind of front line, having to make a choice of Prime Minister from competing contenders. Rather, the parties should themselves try to work out which leader of which party is capable of forming a government, either as a minority government or with sufficient support from other parties to form a coalition government. And in a really lovely part of the manual, what is said is that it's for the incumbent Prime Minister, as the sovereign's principal advisor, to judge the appropriate time at which to resign. So when we get a new Prime Minister, effectively rests on the shoulders of the existing Prime Minister, and that person making a good judgment about when time is or is not up. That is us for this afternoon. Thank you so much to everybody who joined and asked questions. If your question hasn't been answered, we will do that by post separately. And if you get any feedback on the session or any specific questions you didn't want to ask in a public forum, please drop us a line. It was nice to see you. Thank you very much indeed. Bye-bye.
Thank you.